Distinguished guests, colleagues, and students, I appreciate your attending my inaugural lecture. The theme of new technology is central to this lecture. In his book, 21 Lessons for the 21st Century, Yuval Harari suggests that the duo of biotechnology and information technology are set to disrupt our global human civilization. My interest is in a specific kind of biotechnology, namely artificial reproductive technologies, which are, as the name suggests, technologies that enable human reproduction in artificial ways, in contrast with natural reproduction. Since the time that I did my master's research project more than 2 decades ago, I've been fascinated by artificial reproductive technologies as they concern the creation of human life. The idea of the creation of human life reverberates with moral, religious, and cultural significance. Artificial reproductive technologies are set to disrupt many of the values that are deeply ingrained in our traditional way of thinking. In particular, as artificial reproductive technologies develop and incorporate knowledge of the human genome, humanity will gradually gain control over its own genetic composition. Humanity will change from being a natural phenomenon, the product of evolution, to being a cultural artifact. Children will not only be conceived, but will also be made and ultimately designed. Once the strengths of biotechnology and information technology are combined through new artificial reproductive technologies powered by artificial intelligence, humanity can either enter utopia or dystopia. You may think that AI-powered artificial reproductive technologies are a concept somewhere in the distant future. They are not. At least one fertility clinic in South Africa is already using AI imaging technology to select the best in vitro embryos for transfer to the mother's uterus. This is only the beginning. The use of artificial reproductive technologies is heavily regulated in South Africa and in many other countries around the world. Unsurprisingly, this new and burgeoning field of the law, often referred to as reproductive law, has been the subject of significant litigation activity in South Africa over the past decade. For the purposes of this inaugural lecture, I've selected the 3 seminal cases which, in my opinion, have made the most significant contributions to the development of reproductive law. Although it is possible to identify numerous philosophical themes that link these 3 seminal cases, I will focus on the classic theme that has been with us since ancient Greece, the theme of freedom versus authority. In the context of artificial reproductive technologies, this theme is expressed as procreative freedom versus the limitation thereof by the state. I should also tell you in advance that I was involved as counsel in all 3 of these cases. As a result, I will share with you, where appropriate, how I approached certain issues in the litigation and other interesting facts that are not reflected in the judgments. So I invite you to join me on a journey through 3 court battles. My arguments did not always convince the court. Some battles are won, some battles are lost. But overall, I suggest that the trajectory is progressive in the sense that the trajectory favors procreative freedom. The first case in our journey is the case of AB versus Minister of Social Development. The background facts of the case are a decade-long saga of tenacity, fortitude, and persistence personified in the journey of an extraordinary woman who is cited under the pseudonym AB. Her odyssey began in the year 2001, when her pursuit of motherhood unfolded into a compelling story of resilience. During the initial phase of her journey, while in the early bloom of her 40s, AB and her husband undertook 2 cycles of in vitro fertilization, or IVF, using their own genetic materials. Alas, despite the hopeful beginnings, her hopes were thwarted not once, but twice. Following this, AB was faced with a harsh reality. The biological clock had not been her ally, and her own ova were no longer viable for use in conception. A formidable challenge, but not one that could deter AB's resolve. Not one to be deterred by her circumstances, AB embarked on a novel path. She leveraged the benevolence of anonymous donors and proceeded with 2 more IVF cycles using donor ova and her husband's sperm. However, despite these fervent efforts, success continued to elude her. In the year 2002, life cast another blow. After 2 decades of marriage, her relationship ended, so leaving her to navigate her journey to motherhood alone. Nevertheless, her spirit remained unbroken. AB embarked on a series of 9 IVF cycles using both donor ova and donor sperm. Yet, her dreams were once again deferred, with each attempt failing to bring her closer to her cherished goal of motherhood. By 2009, AB took another leap of faith and switched fertility clinics. This shift brought with it a glimmer of hope and resulted in 2 pregnancies, but tragically, both ended in miscarriage. With the stark words of her fertility specialist echoing in her ears, the odds of a successful pregnancy were virtually non-existent. AB was confronted with the stark reality of her irreversible infertility. Towards the end of 2009, however, AB was presented with a new path to explore: surrogacy. Through a surrogacy agency, a surrogate mother was found who was willing to assist AB. But despite the evident joy, a legal roadblock arose. First, some background. In South Africa, surrogacy is governed mainly by Chapter 19 of the Children's Act. It provides a scheme in terms of which a commissioning parent or parents and their surrogate mother must enter into a surrogacy agreement and apply to the High Court to confirm their agreement prior to the planned surrogacy pregnancy. Provided that the child is not genetically related to the surrogate mother, a surrogacy agreement that was confirmed by the High Court is enforceable, and the child must be registered as the child of the commissioning parent or parents at birth. Any surrogacy agreement or arrangement not in compliance with this scheme is unenforceable and unlawful. However, one element of the statutory scheme posed an obstacle to AB. Section 294 of the Children's Act requires that surrogacy commissioning parents must use their own gametes for the conception of a surrogacy child. This excluded AB, as it had long since been established that her own ova were unsuitable for use in IVF. AB received this legal advice with a mixture of shock, sadness, and bafflement, especially given that she had been legally allowed to use both male and female donor gametes for several years while attempting to achieve pregnancy herself using IVF. Accordingly, AB decided to confront this predicament head-on by challenging the constitutionality of Section 294 of the Children's Act in court. In this quest, she was joined by the Surrogacy Advisory Group, as second applicant. Some years later, the Surrogacy Advisory Group would launch an audacious legal challenge of its own. I will return to this a little bit later in the lecture. The gist of AB's legal argument was that the impugned provision, that's now section 294 of the Children's Act, was arbitrary and that it discriminated against her based on her status of being infertile. Let me explain the argument. If a woman is fertile in the sense that she can carry a pregnancy herself, she's legally entitled to select to use male and female donor gametes. However, if she's infertile in the sense that she cannot carry the pregnancy herself and must use a surrogate mother, the legal position becomes the inverse. Now she's legally prohibited from using donor gametes. Is this not discrimination based on infertility? AB further argued that the impugned provision infringes her procreative freedom, expressed in the rights to dignity, privacy, and bodily and psychological integrity, and infringes her right to access reproductive healthcare services. However, the Minister of Social Development opposed AB's application and was supported by the University of Pretoria's Centre for Child Law. Their argument was that the best interests of the prospective child demand that the prospective child must have a genetic link with at least one commissioning parent, and if there's only one parent, with that parent. This argument rests on two presuppositions. First, a presupposition of a legal principle, that the constitutional protection of the best interests of the child extends to the prospective child. And second, an empirical presupposition that children are harmed by not knowing their genetic origins, or at least that not knowing one's genetic origins is not in one's best interest. The first presupposition proposed a significant development in our law, that the court must, in constitutional matters concerning prospective children, consider their best interests, and that the interests of prospective children, persons who are not yet in existence, can limit the rights of existing persons. Interestingly, all the parties involved in the litigation accepted this presupposition, and so did the court, both in its minority and its majority judgment. This was a remarkable event, and I suggest may still be highly consequential in future. But what exactly is the prospective child? Is it an embryo? Is it a fetus? Perhaps a sperm cell? This crucial question was not considered in AB, and I will return to this question when I discuss the next case. But how was AB decided? Since the parties all agreed on the first presupposition, the legal battle focused on the second presupposition, which made an empirical claim that children are harmed by not knowing their genetic origins, or at least that not knowing one's genetic origins is not in one's best interest. Here, the applicants, that is AB and Surrogacy Advisory Group, filed expert opinions by world-leading psychologists to prove that the second presupposition is false. The minister filed an opposing expert opinion by a bioethicist, but this expert opinion was thoroughly discredited in the applicant's papers, so much so that the minister eventually abandoned any reliance on her own expert. The Centre for Child Law referred the court to two academic articles on children and genetic relatedness, but the content of these articles was a precarious basis for an empirical claim that children are harmed by not knowing their genetic origins, or at least that not knowing one's genetic origins is not in one's best interests. However, in a stunning display of post-truth jurisprudence, the majority of the Constitutional Court ignored the evidence before it and sided with the minister and the Centre for Child Law. In the end, AB sadly lost her case. Her long quest to become a mother ended in naught. But I can now add that a decade later, the new case of KB, which was launched in Mpumalanga based on different facts, offers a glimmer of hope to rectify this injustice over time. While I am critical of the majority judgment in AB, the minority judgment penned by Justice Kampepe and concurred to by Justices Cameron, Fruneman and Madlanga is an 84-page long tour de force infused with both reason and compassion. It is a must-read for all South African law students. At the basis of the minority judgment is the recognition that the right to procreative freedom is not limited to natural procreation, but also includes the use of artificial reproductive technologies. Importantly, on this basic point, the majority judgment was quiet. Accordingly, the minority judgment's interpretation of the ambit of the right to procreative freedom as including the use of artificial reproductive technologies stands uncontradicted and constitutes persuasive authority. This, I suggest, is clearly a milestone in South African reproductive law. It is worth quoting the following inspiring passage from the minority judgment. I quote, "We are fortunate to live in an era where the effects of infertility can be ameliorated to a large extent through assisted reproductive technologies. The technological advances seen over the last half-century have greatly expanded the reproductive avenues available to the infertile. These reproductive avenues should be celebrated as they allow our society to flourish in ways previously impossible." End of quote. The minority judgment stands as a beacon of hope for future generations of lawyers who aspire to justice. Let me now return to the crucial question that was left unanswered in AB, namely, what exactly is the prospective child? This question was answered in the subsequent case of Expart Kf2. This case unfolded an array of legal questions that went beyond the scope of a seemingly typical surrogacy confirmation application. I should note that I was not initially involved in this case. At the helm of the case were the commissioning parents, a couple whose journey to parenthood had been hindered by medical hurdles since their union in 2006. Following the futile pursuit of parenthood through 5 IVF cycles, the couple was introduced to a potential surrogate mother, a young woman of 20, who was already a mother of 2. The commissioning couple had 4 unused in vitro embryos remaining after the 5th failed IVF attempt and planned to use these embryos for the surrogacy pregnancy, as they had been created from the couple's own gametes. Despite the seeming simplicity of the case, where the clinical psychologist's reports appear to favor the suitability of the parties involved, the application faced an unexpected setback in court. The suitability of the intended surrogate mother was questioned by the court. The fact that she became a mother at the age of 17 and never returned to finish school was under scrutiny. The court, despite the psychologist's report, found it difficult to believe that the intended surrogate mother had the emotional maturity to comprehend the magnitude of her decision to become a surrogate mother, and dismissed the surrogacy confirmation application. It was at this stage that I was briefed in the case. The problem, as I saw it, was that there were no objective criteria for assessing the suitability of an intended surrogate mother. As a consequence, lawyers, psychologists, and judges all applied their own idiosyncratic criteria. Accordingly, I devised the following solution. First, I convened a panel of 3 psychologists to draft a set of objective criteria for surrogate mother suitability assessment. Next, I requested a 4th psychologist to interview the same intended surrogate mother in the light of the set of objective criteria. This psychologist provided a positive report of the intended surrogate mother and commented that penalizing her for her past decisions was unfair, and suggested instead that the focus should be on her evolved emotional maturity. Thus, the parties relaunched their application in the Johannesburg High Court with supplemented papers. Importantly, the Johannesburg High Court accepted the set of objective criteria developed by the panel of psychologists and incorporated it in its judgment. In this way, the set of objective criteria for surrogate mother suitability became part of our law and has provided guidance to psychologists, lawyers, and judges ever since. Next, the Johannesburg High Court also accepted the new psychological report on the intended surrogate mother. However, the court raised a new issue during oral argument with me. Since the commissioning couple already had 4 cryopreserved embryos, was it not incumbent upon the court to consider the best interests of each one of these embryos? And if so, what would this entail in practical terms? It was a broad and open question, but highly consequential for reproductive law. As such, I promised the court that I would file supplementary heads of argument to address this question. I was on my way to a conference in Paris, so instead of visiting the Louvre, I had to work on these supplementary heads of argument. But at least I could sit and work in a Parisian coffee shop while eating macaroons. I argued that the prospective child is not something tangible, but rather an idea in our minds. And that this idea of the prospective child can exist in our minds irrespective of whether one already has embryos or not. In other words, the idea of a prospective child is not linked with a specific in vitro embryo. Accordingly, none of the in vitro embryos can be equated with the prospective child. There is, of course, a potential link between the in vitro embryos and the prospective child, namely that the in vitro embryos are the biological material that may, if the pregnancy is successful, give rise to the prospective child. I'm happy to say that my written submissions convinced the court, and the essence of my submissions was incorporated into the judgment in Expart Kf2. This is highly consequential for reproductive law, as it provides a clear theoretical basis for understanding the legal relevance of acts directed towards the in vitro embryo. It confirms the well-established position in South African law that the embryo itself does not have any interests or rights. However, this does not mean that there is legal carte blanche to do anything with the embryo. If an act directed towards an embryo is likely to have an effect on the prospective child, the interests of the prospective child are indeed legally relevant. The next case that I'm going to discuss is surely the most controversial and a true test of the depth of South Africa's commitment to procreative freedom. It is the case of Surrogacy Advisory Group versus Minister of Health. At the heart of this case was the issue of sex selection. By the way, my colleague Sheetal Soni wrote an excellent doctoral thesis on this topic a few years ago. To fully understand sex selection and the legal arguments surrounding it, I need to tell you a bit more about 2 technologies. First, pre-implantation genetic testing for aneuploidy, or PGTA, and second, non-invasive prenatal testing, or NIPT. In normal human development, we inherit 23 chromosomes from each parent to make up a total of 46. However, sometimes errors occur during cell division, and embryos may end up with a missing or an extra chromosome, a condition known as aneuploidy. Aneuploidy is a leading cause of miscarriage and can result in conditions such as Down syndrome. PGTA is designed to detect aneuploidy in an embryo before the embryo is transferred to the woman's uterus. It entails taking a biopsy sample of a few cells from an in vitro embryo, and the sample is then tested for aneuploidy. This test helps identify which embryos have the correct number of chromosomes and therefore have the best chance of leading to a successful pregnancy if implanted. Importantly, PGTA also discloses whether an embryo has XX or XY chromosomes. As a result, using PGTA technology, parents can select the sex of the embryo to be transferred to the mother's uterus. I now turn to the second relevant technology, NIPT. Whereas PGTA is performed before an embryo is transferred to a woman's body, NIPT is performed at about 10 weeks of pregnancy. NIPT entails taking a blood sample from the mother's arm. This testing detects small pieces of DNA from the placenta known as cell-free DNA, which circulate in the mother's bloodstream. Similar to PGTA, NIPT also tests for aneuploidy and reveals the sex of an embryo. NIPT is typically used for detecting conditions such as Down syndrome, which can then be followed by termination of pregnancy. However, it can also be used for sex selection. The pregnant woman can terminate her pregnancy if the embryo is not of the desired sex. She can then attempt to fall pregnant again and repeat the process until she is pregnant with an embryo of the desired sex. In 2012, the Minister of Health promulgated the regulations relating to the artificial fertilization of persons, which prohibit the use of any pre-implantation or prenatal test to select the sex of a child, except if the selection is for medical reasons, that is, to avoid a sex-linked genetic disorder. This means that it is unlawful to use either PGTA or NIPT for non-medical sex selection. However, is this prohibition not a limitation on the procreative freedom of intended parents? And if so, can it be justified? These were the core issues in Surrogacy Advisory Group versus Minister of Health. The Surrogacy Advisory Group, suing in the public interest, challenged the constitutionality of the prohibition against non-medical sex selection. My litigation strategy was to avoid an argument which directly claims that using PGTA technology for sex selection falls within the ambit of procreative freedom. My reasons for avoiding such an argument were, first, because the minority decision in AB that artificial reproductive technologies fall within the ambit of procreative freedom only had persuasive force, and second, the highly controversial nature of sex selection. Instead, my litigation strategy was to rely on the Choice on Termination of Pregnancy Act, the Choice Act in short, and to contrast the procreative freedom that women enjoy under the Choice Act with the impugned provision in the regulations that restricts such freedom. Let me explain my argument. Generally speaking, the Choice Act strikes a balance between the procreative freedom of the pregnant woman and the interests of the state in protecting prenatal life. During the first trimester, the procreative freedom of the pregnant women supersedes the state's interest. Then, from the second trimester, and increasingly so in the third trimester, the state's interest supersedes the women's procreative freedom. For example, in the third trimester, only a select number of factors, such as the life of the pregnant women, can supersede the state's interest in protecting prenatal life. However, our focus is on the first trimester. During this period, the Choice Act provides that a woman can terminate her pregnancy without having to provide any reason. In other words, any reason, including sex selection, is a good enough reason to terminate the pregnancy. Remember that NIPT can be used as early as the 10th week of pregnancy. As a result, the Choice Act makes it lawful for a pregnant woman who is intent on selecting the sex of her child to practice first trimester prenatal sex selection. To the extent that the regulations, which is subsidiary legislation, are in conflict with the Choice Act, which is primary legislation, the regulations are invalid. But where does this leave pre-implantation sex selection? In other words, sex selection at the in vitro stage. If the law allows prenatal sex selection via the Choice Act, but prohibits pre-implantation sex selection via the regulations, the law effectively forces a woman who is intent on selecting the sex of her prospective child to use NIPT at 10 weeks of pregnancy, together with elective termination of pregnancy and possibly repeated pregnancies, rather than allowing her the option of pre-implantation sex selection. This has a negative effect on the woman's bodily integrity and psychological integrity. Let's consider her bodily integrity. While pre-implantation sex selection entails no medical risks, termination of pregnancy does entail physical discomfort and medical risk. Thus, bodily integrity is compromised. Let's now consider her psychological integrity. While pre-implantation sex selection does not require the destruction of the women's in vitro embryos, termination of pregnancy, per definition, destroys an embryo in the woman's body. Many women value embryonic life. Thus, psychological integrity is infringed. The Minister of Health answered the Surrogacy Advisor Group's argument by denying that there is any infringement of the right to bodily and psychological integrity of a woman, as the in vitro embryo that can be tested through PGT-A is outside the woman's body. However, this position is blind to the effect that the ban on sex selection has on a woman's body, and therefore did not pose a significant obstacle. The minister further argued that in the event that the court found that there is an infringement of the right to bodily and psychological integrity, the state has a legitimate government purpose in prohibiting non-medical sex selection, as it is inherently sexist and unethical. This, I suggest, was the minister's strongest possible position. In reply, I argued that our constitution embraces the idea of a value pluralism, and that the state cannot enforce the moral convictions of one section of the population on everyone. I illustrated my argument as follows. In our country, we have, amongst others, traditional nuclear families, husband, wife, and children, polygamous marriage families, interracial families, same-sex families, adoption families, and single-parent by choice families. There is clearly significant diversity, but all these families deserve equal concern by the state. Regarding sex selection, there can be a multitude of reasons for wanting a child of a certain sex. which would depend on each family's circumstances. It could be a parent wanting a companion of a certain sex, feeling more able to rear a child of a certain sex, or wanting to build a family with a desired composition of boys and girls. These are all personal reasons in the context of family life of different families. Importantly, one may not agree with the way in which other families live their lives or raise their children. For example, one may believe that polygamy is immoral, or same-sex marriage is immoral, or interracial marriage is immoral, but this is one's own private moral opinion. It would be antithetical to our constitutional dispensation to try to enforce such private morality through the law. Yet, I argued that this is exactly what the impugned provision does. The court's judgment on the issue of sex selection is over 5,000 words. Contrary to my position, the court held that sex selection is inherently sexist, as it relies on stereotypes of what it means to be a boy or a girl. I do not agree, of course, but however, the court held that this issue is overshadowed by a woman's right to procreative freedom. The court agreed with my argument based on the contrast between the Choice Act and the impugned provision in the regulations. The court observed that women need not give reasons for the termination of her pregnancy in the first trimester, and that this means that should a woman choose to terminate her pregnancy because of the sex of the embryo, she is free to do so. The court held that this creates an untenable situation where prenatal sex selection is lawful in terms of the Choice Act, but pre-implantation sex selection is prohibited by the regulations. As a result, the court held that the impugned provision in the regulations is unconstitutional. What is most remarkable about the judgment is that despite my own reticence about arguing that sex selection falls within the ambit of procreative freedom, the court arrived at this conclusion itself and explicitly held, I quote, "Sex selection can be understood as part of reproductive autonomy. The available technology just increased the number of options, thereby increasing reproductive liberty." End of quote. I must admit that I was pleasantly surprised when I read this. In retrospect, I should actually not have been surprised, as this simply is the correct legal view of how the ambit of rights must evolve in synchronization with the advent of new technology, even if the new technology is controversial. As the legendary Justice Sachs remarked in the momentous case of Minister of Home Affairs versus Fourie, I quote, "Indeed, rights by their nature will atrophy if they are frozen." End of quote. This interpretation of the ambit of procreative freedom, both by the AB minority and by the court in Surrogacy Advisory Group, lays a solid foundation for building a progressive reproductive law in South Africa. We have now reached the end of our journey through the three seminal cases, and it is time to reflect. I suggest that two core principles have crystallized. First, procreative freedom includes within its ambit the use of new artificial reproductive technologies, irrespective of whether the use of such new technologies is deemed controversial or unethical. Although the use of new artificial reproductive technologies does not directly affect any existing person, it does potentially affect the prospective child. From this flows the second principle, namely that the scope of possible procreative decisions that prospective parents may take, at least in the context of using artificial reproductive technologies, should be legally limited to exclude decisions that will cause harm to the prospective child. My colleague Bonginkosi Shozi and I called this the principle of procreative non-maleficence. Although for legal analytical purposes it is based on the AB judgment, it aligns with classic liberal theory and essentially applies John Stuart Mill's dictum that freedom can be limited only if it harms somebody else in the context of the use of artificial reproductive technologies. Guided by the twin principles, the progressive pluralist interpretation of procreative freedom and the principle of procreative non-maleficence, we stand poised and ready to embrace the challenges emerging in the landscape of reproductive law as science marches forward. The rippling disruption that biotechnology and information technology and their intersection will surely bring is an outcome we cannot shirk from. Yet, it is within our hands to channel these seismic disruptions, to harness their formidable power in service of creating a brighter and a better world. The twin principles I have distilled from our legal precedents serve as our compass, as navigational aids within the realm of reproductive law. They will ensure that we as a society relish the bountiful fruits of new technology, while vigilantly steering clear of pitfalls. This is a future that is worth aspiring to. I thank you.